Hi class, I hope everyone is doing well. Now that you have demonstrated your competence and understanding of the legal concepts presented in the first half of the semester, I want you to demonstrate how to apply those legal concepts to sport-specific situations. So the midterm exam part 2 is an opportunity for you to apply legal concepts to a sport-specific case study that I have written because I want to evaluate your ability to appropriately apply the law. If you go to the contract law module and scroll down to the very bottom, you will see two things. Midterm exam part 2 materials. This document right here provides you with a rubric and instructions for midterm exam part 2. It also provides you with the case study that you will be analyzing. And then once you have completed the midterm, you can submit that document through this assignment submission, midterm exam part 2. Now this document, I have it already pulled up on my computer and I wanted to walk you through it. As you will see right here, you can complete the midterm exam part 2 in a group of up to 7 students if you wish to do so. You can divide out the work and this could be done over email. It's probably not even necessary to meet in person. However, I do encourage you, if you do choose to work in a group, that's completely optional, that you review your partner's work to make sure that everything looks good before you submit your final exam. Just make sure that all students' names are on the final exam that you submit because everyone will be receiving the same grade. Scrolling down, here's the evaluation components. Now, after the introductions, you'll see the case study. It's about a page and a half, and then you'll see additional questions. So these evaluation components are based on this case study and the additional questions. The case study was written to have a minimum of 7 possible lawsuits. Think of the case study like the facts of the case section of a case brief. It is a sports situation that describes incidents in which the victim could potentially file a lawsuit. So you need to identify 7 lawsuits total. And I outline right here that you need to identify 4 negligence lawsuits, 2 assault or battery lawsuits, it might be a combination, and 1 defamation lawsuit. So you need to find these 7 lawsuits. And for each of those lawsuits, you need to include these elements. I found that the most effective organization approach for the midterm exam is to complete these components 1 lawsuit at a time. So you would identify, okay, a negligence lawsuit, and then you would identify this is the plaintiff, this is the defendant. The plaintiff is charging negligence, and these other complaints possibly. This would be in a civil court. So identifying the lawsuits and then working your way down seems to work the best. But for each lawsuit, make sure you identify the specific plaintiff and defendant. Identify the legal complaints that the plaintiff is filing. Most likely it is negligence, assault, battery, defamation, one of those. I want you to clarify that so that I can understand the rest of your analysis. And then you will identify whether it's a civil or criminal lawsuit. I want you to recall that in the PowerPoint and in your readings. For a civil lawsuit, the plaintiff is a citizen. It's the individual who is harmed, the victim, and they are seeking a remedy for their injuries, the reason why they file a civil lawsuit. However, in a criminal lawsuit, the plaintiff is a state or federal prosecutor who is filing this complaint on behalf of society as a whole. And so if you're choosing civil or criminal, really think about who's the plaintiff that you just identified. If it's the victim, then it's a civil lawsuit. However, if it's a state or federal prosecutor, then it's a criminal lawsuit. The intentional tort claims such as assault and battery can be filed in either civil or criminal. So for that, you could do one or the other. Up to you. And then once you've identified those components, you will discuss the arguments for both parties. So you'll start off by identifying the plaintiff's legal principles. And what I mean by legal principles is for negligence, for example. In order to prove negligence, there are 4 elements of negligence that you have to prove. Duty, breach of duty, proximate cause, and injury. So those are the legal principles. Those 4 elements are necessary for negligence. I will be looking for those terms. Same thing with assault and battery. Those have 3 legal principles. For assault: intention to harm, reasonable apprehension of immediate harm, and lack of consent. And then defamation, that has 4 elements. So I will be looking for those specific 3 or 4 legal principles that are associated with that legal complaint. Identify the right terminology. And then next you'll apply the information from the case study. So if negligence is duty, breach of duty, proximate cause, and injury, for the specific incident that you are analyzing, tell me, what was the duty of the defendant? What was their breach of duty? How is their breach of duty a proximate cause to the injury? And then specify what was the injury. So you're taking details from the case and you are applying them to the 3 or 4 legal principles that you identified, which are associated with that primary legal complaint. After you do that, you'll discuss possible defendants that the defendant could use. Now, when you're discussing possible defendants, I really want you to think about relevance. Which defenses are viable for the specific situation that you're analyzing, the specific lawsuit? I don't want you to list every single possible defense for assault, every possible defense for defamation, because they might not be relevant or pertinent to the specific lawsuit that you're discussing. So really try and think about relevance and what would be appropriate. Next, after you have presented both arguments from the plaintiff and the defense, you are going to come up with a likely judgment. In this, I want you to tell me which party would likely win the case and why. So what's your judgment and what's your reasoning for that judgment? So you're walking me through the complete lawsuit of what would happen based upon your own judgment and your own understanding of the law. After you have done these elements for every lawsuit, okay, every lawsuit, you will respond to the additional questions at the end of the case study. They're more practical application questions, and if you can write a minimum of a paragraph for each question, that would be a minimum expectation. Try and be thorough and comprehensive in your responses. Really think about how to respond to those questions and present a lot of ideas. Okay. In terms of formatting, you can see that bullet point answers are completely acceptable. However, I would prefer a narrative for the additional questions, and please, if possible, use complete sentences. It would just be helpful. And then this is the case in the additional questions. To further help you out, I thought I would go through an example. So here's an example case study that I have written. This case study is written so that there are 6 possible lawsuits: 2 negligence, 3 assault or battery, and 1 defamation. So to read through this case study, it says you're a student in the SBTA 300 class during the spring semester at Ball State. You show up to class 10 minutes early on Tuesday and find your seat. You begin to have a conversation with Drew, who is sitting behind you, about the upcoming midterm exam. At 12:30, when class is supposed to start, Dr. Lauer, the instructor, walks into class and begins to take attendance. In the midst of taking attendance, Dr. Lauer realizes that she left the midterm review handout in her office and decides to leave the classroom at 12:35 to go retrieve the handout, and communicates that she will be back in 5 minutes. While Dr. Lauer is gone, you continue your conversation with Drew about the review activity from a few weeks ago. Drew tells you he knows for a fact that Dr. Lauer steals all of her class lectures, assignments, exams from Dr. Wanless, who had previously taught this class. Drew intentionally speaks this loud enough for the entire class to hear, and says that he plans on telling other students in this major to not take classes with Dr. Lauer because she plagiarizes other teachers' ideas, stealing their intellectual property. which is not true. Mike gets bored with Drew's rant and begins to boast about how many questions he got right on the review activity. Aubrey overhears Mike's comments about his score and argues that she had the best score out of the whole class by a mile. Aubrey's argument makes Mike laugh, but Derek, who is sitting right next to Aubrey, gets really upset. Derek begins to yell at Aubrey, saying he is the king of sports law. He gets so close to Aubrey that she tries to back away out of fear of harm, but has nowhere to go. Jordan from across the room walks over to Derek to try and calm him down, but he just pushes her away, at which time she trips over a chair located in the aisle and hurts her ankle. The chair should have been behind a desk, but Dr. Lauer moved the chair in the middle of the classroom to stand on it and manually turn the projector on. Dr. Lauer forgot to place the chair back in its original position after turning the projector on. Clayton feels like Derek has gone way too far and is afraid for Jordan, so he grabs Derek by his arm and drags him out of the classroom. Through the process of dragging Derek by his arm, Clayton dislocates Derek's shoulder and he has to go to the hospital to get it relocated. So if you're looking at, okay, I need to identify 2 negligence lawsuits. Well, one would probably be that I left the classroom when class had already begun. I have a duty to supervise and to care for the students in my classroom. So because I broke that duty, the injuries such as Derek's shoulder, guess what? I would have never let Clayton drag Derek out of the classroom. That wouldn't have happened if I hadn't had left. So Derek's shoulder injury is partially my fault. So that would be a negligence lawsuit. Or the fact that I left the chair in the middle of the aisle, which Jordan tripped over. It's negligent to leave an area unsafe with hazardous conditions. So those would probably be the 2 negligence lawsuits. In terms of assault or battery, there are quite a few. One is that Derek begins yelling at Aubrey, and he gets so close to Aubrey that she tries to back away out of fear of harm. That is an assault lawsuit Aubrey would file against Derek. A few others, let's see. Clayton feels like Derek has gone way too far and drags Derek out of the classroom, dislocating his shoulder. That is a battery lawsuit. He touched Derek, he caused injury, he intended to do so, and Derek provided no consent. Let's move on to the defamation lawsuit. That one is pretty obvious right here. Drew is claiming that I stole Dr. Wanless's intellectual property, and that statement could hurt my reputation as a faculty member. And so that would be the defamation lawsuit. And let's see. Okay. Moving on. So if we were going to walk through the case, really quickly, I want to walk through each of the elements. So let's focus on, let's see, Clayton and Derek, this battery situation. So first thing, who's the plaintiff? That would be Derek, who is the victim. Who is the defendant? That would be Clayton, who contacted the victim, Derek. Now, what would the legal complaint be? It would be battery. This would be a civil lawsuit because Derek is the one filing the lawsuit. What are the legal principles? Well, the first legal principle is that Clayton intended to touch Derek, which is evident right here. Clayton feels like he has gone too far, so he grabs Derek. That is intent. Actual touching occurred. He grabs Derek by his arm. That is support for actual touching. And then there was no consent. There's no consent indicated anywhere. And then there's also injury. However, that's not necessary for a battery complaint. In terms of the defense, one possible defense that you could talk about is privilege, is defense of a third party. Clayton felt like he had gone too far and he was afraid for Jordan. So Clayton was protecting a third party who is Jordan. So that would be a viable defense that you could talk about. And then in terms of the final judgment, most likely Derek would win because Clayton's actions were completely outrageous. He could have had other means to try and protect Jordan without touching Derek, and especially without dislocating his shoulder. So that's an example of how you would go step by step through the case study, and you would do that for every single lawsuit. If you need any help at all, if you have any questions, please do not hesitate to contact me. We can email, we can talk, you can come to my office, anything of that nature. Please be specific and articulate and thoughtful in your responses. I don't know what I'm trying to bring up. And best of luck on midterm exam part 2.